The House will come to order. The Pledge of Allegiance will be led by Representative Hartsook.
Good morning. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Woo-hoo!
Mr. Schiebel, please call the roll.
Representatives Armagost, Bacon, AML Bacon,
Excused.
Barone, Byrd, Basenecker, Bottoms, Representative Bottoms,
Excused.
Bradfield, Bradley, Brooks, Brown, Caldwell. Caldwell's excused. Camacho, Carter, Clifford, DeGraff, Duran, English, Espinoza, Foray, Froelich, Garcia, Garcia Sander, Gilchrist, Gonzalez, Hamrick, Hartsook, Jackson, Johnson, Joseph, Kelty. She's right there. She's here. Leader, Lindsay, Lindstead, Luck, Lukens, Mabry, Marshall, Martinez, Morrow, McCormick, Pascal, Phillips, Puglisi, Richardson, Ricks, Representative Ricks. Ricks is excused. Rutinell, Ryden, Sirota, Smith, Soper, Stewart K, Stewart R, Story, Representative Story, Sukla, Taggart, Titone, Valdez A, Rep Valdez is excused. Velasco, Weinberg, Wilford, Winter, Woodrow, Woog, Zokai, and Madam Speaker.
Thank you for your patience, members. With 61 present and 4 excused, we do have a quorum. Representative Hartsook.
Good morning, Madam Speaker. How are you today?
I am so good, Representative. How are you?
I am just peachy, and I am here to pitch hit on the Journal. So as you notice outside the chamber, it's beautiful weather up here in Denver. Down in Douglas County, we kind of have a blizzard going on, so some of our folks are stuck in that traffic. And I would ask for your consideration at this moment of pitch hitting and the blizzard going down as Mother Nature moves through, that we could get an aye vote today. Normally it's for Loveland, but we're going to ask for today, it's for Douglas County. Therefore, Madam Speaker, I move the Journal of Wednesday, January 29th, 2025 be approved as corrected by the Chief Clerk.
Members, you've heard the motion that the Journal be approved as corrected by the Chief Clerk. All those in favor and for Douglas County, say aye.
Aye!
All those opposed, no. The ayes have it. The motion is adopted. Members, we are ready to get to business. Members, I'll invite you to take your seats. Madam Majority Leader, when you are ready. Thank you. Assistant Majority Leader Bacon. Not yet, but I was checking. Thank you. Madam Majority Leader.
Thank you, Madam Speaker. I move the following bills be made special orders on January 30th, 2025 at 9:15 a.m. House Bill 1077, House Bill 1035, House Bill 1050, House Bill 1081, House Bill 1034, and House Bill 1003.
Seeing no objection, the bills listed by the Majority Leader will be made special orders on January 30th, 2025 at 9:15 a.m. Assistant Majority Leader Bacon. Members, you've heard the motion. Seeing no objection, AML Bacon will take the chair.
Okay. The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the Majority Leader, and the court rule is relaxed. Mr. Schiebel, please read the title to House Bill 1035. She moved it? Did I move that? Did I acknowledge it? 1077. Please, Mr. Schiebel, please read the title of House Bill 1077.
House Bill 1077 by Representatives Leader and Ricks, also Senator Roberts. concerning requirements for individuals who work on backflow prevention devices and in connection therewith, removing the licensure requirements for individuals who inspect, test, or repair the devices.
Committee will go into a brief recess. The committee will come back to order. Madam Majority Leader.
Thank you, Mr. Chair. I'd like to proceed out of order for the consideration of House Bill 1050.
We will move out of order. We will consider House Bill 251050. Mr. Shebo, please read the title.
House Bill 1050 by Representative Garcia, also Senator Amabile. Concerning an exception to the requirement that a county with a population of 2,000 or more maintain its own county jail for a county that enters into an intergovernmental agreement for a multi-jurisdictional county jail.
Representative Garcia.
Thank you, Mr. Chair. I move House Bill 251050 and to the committee report. No, I don't have a committee report. Just the bill.
To the bill.
Thank you, Mr. Chair. Members, this is quite a simple bill. The history of why this bill exists is just a teeny little bit longer, so just indulge me for a hot minute. So we have a state law that required every single county to update and upgrade their jails. And if they weren't able to actually update and upgrade their jails, they'd have to build a new one. Now, those that were stuck building new ones were actually more of our smaller counties. So now what we're having to do is counties engaged in intergovernmental agencies so that they wouldn't have to build a jail, but they would work together with their neighboring counties to be able to satisfy the requirement of humane housing. This bill is a bill that is intending to codify the ability to engage in these intergovernmental agreements in order to make sure that our smaller communities and our smaller counties are not found out of compliance with the law, but are still upholding and maintaining the jail standards that are adopted. So it's a zero-cost bill, and it allows for counties to communicate, and it also allows for everyone who is being held in a local jail to be in a safe place. And I ask for an aye vote.
Representative DeGraff.
Thank you, Mr. Chair. I think it's okay that we're looking at a level of government efficiency here, and it's a necessary level of government efficiency. But I think we dealt a little bit with this when the bill was passed, because I don't know. I think we could see this coming. We had jails saying we cannot afford these. We cannot afford to do this. We cannot afford to do this. And instead of stepping back and saying, all right, let's listen to our counties, and instead of just outright imposing the good intentions with the unlimited pocketbook called taxpayers, we just went ahead and blew through it. When we should have stopped and listened and said, okay, these counties are not going to be able to afford this, so how do we make this happen without just imposing it? So now we have a bill that has an emergency clause on it, possibly rightfully so, but we have an emergency clause on a bill because this body didn't do its job. This is a bill mill. And we churn out bills with very little oversight, and anytime the supermajority last year didn't want to listen, didn't listen. And I think this would be one of those times, a good example of one of those times when you should have listened. So now we have another bill as a cleanup, because the bill mill didn't want to take time to do the due diligence to know exactly what was going to happen when the counties couldn't afford this. And it was just the assumption that we will just spend more money of the taxpayers again and again and again. And now we're $5.5 billion in the hole. So I think this emergency clause is a testament to the way the bill mill is run. We're just churning out bills, one after the other, creating more problems instead of taking the time to solve them. So I think we probably need this bill, but I think we ought to take it under advisement that maybe we need to slow down and understand that other people have opinions, even if they're not in the majority party, and they might actually be trying to help.
Representative Armagost.
Thank you. So seeing this bill in judiciary and also seeing this bill in jail standards, we can always get a little concerned when we hear something's a simple bill. There are some technical issues that we're looking at, but as you see, this passed out of judiciary unanimously for the simple fact that I'm in 8th Judicial District, which is Larimer and Jackson counties. So we have the large jail, small jail thing, and that ability to collaborate, that ability for them to pair up and get funding, get resources, get beds that they need is important. So we are still looking at something I need to talk to the sponsor about, but at the same time, this is something that we do need to help maintain and work our jails into an ability to collaborate with other jails, whether it's large and small, and have that ability to not only share bed space if needed, but also the funding that they need for the sheriffs that we heard from in Lake County and other counties that are dealing with this and dealing with that shortage, dealing with the inability to house and maintain contracts they have with their local law enforcement agencies is important. So I would encourage a yes vote on this. And that's all I got. Thank you.
Representative Kelty.
What is down? Okay. This, as Rep. Armagost had mentioned, this bill did come through judiciary, and one of the things that I always look for is whether there's a fiscal note, whether it's saving money, whether it's spending money, and for this bill. For this bill, it actually is saving money. Whether it's saving the state, whether it's saving the county, whether it's if it's saving the taxpayers in one way or another, I'm for that and in a positive way. And that is exactly what this bill is doing. I appreciate the fact that it's being brought up because one of my things that I've always talked about was we need to go back and look at bills where we have broken things. In the past few years, we've broken a lot. So I'm appreciative of this bill coming forward and actually fixing something that was broken that's actually a positive for the taxpayers and our Coloradans. So I would hope that we can get a yes on this vote today. Thank you.
Representative Taggart.
Thank you, Mr. Chair. It's an honor to serve with you. I'm just here to fill time to help one of my colleagues, Representative Garcia, that if you look in the ledge deck for a moment on this particular bill, number 2 in the ledge deck is in fact a statement about the fact that the General Assembly finds and declares it necessary to incentivize small counties to do this. That's been taken out of the bill, and my request that they're working on right now, and I'm trying to fill time to allow them to do that, is to take that out of it because it's no longer in the bill, so it's a bit misleading. So bear with us as they try to make that change.
Thank you. Minority Leader Puglisi.
Thank you, Mr. Chair. I did not sit in the Judiciary Committee. It sounds like there's been a lot of really great conversation about this bill on both sides of the aisle, and I want to say I really appreciate the bill sponsor for being so willing to take our comments. I know she's working on an amendment right now to address an issue, but I just want to say, you know, we really do appreciate when our voices are heard inside and outside of committee. We want to make sure that we are passing the best policies for this building and for the people of Colorado. I'm really just grateful for the opportunity to have these conversations and appreciate that everyone is listening to me in this room right now. I don't know, somebody. I think, perfect. Thank you. It sounds like the bill sponsor, or nope, the bill sponsor is still working on these great amendments to make this bill better and to really solidify policy in Colorado. And at this point, I will defer, I am not a filibusterer, to one of my colleagues. Thank you.
Representative Luck.
Thank you, Mr. Chair. Well, it is unfortunate that once again this year I'm not on the Judiciary Committee, so I feel as if it's necessary to take this opportunity to act as if I am on the Judiciary Committee and ask some questions. So, as relates to the specific language in this bill, on page 3, section 2, there is a note here that a county that maintains an IGA, otherwise known as an intergovernmental agreement, or any other contract. My eyes go to the or any other contract with at least one other county. What are other contracts with other governmental entities that are not IGAs? What kind of example is that? If somebody could help me out, I don't know what kind of agreement two governments can enter into that doesn't actually qualify by definition as an intergovernmental agreement. So if somebody could come up here and have a robust conversation with me about contract law and as relates to local governments, perhaps someone in my caucus who is an attorney for governments or other, someone who sat on the Judiciary Committee, I would be grateful. Thank you.
Representative Caldwell.
Thank you, Mr. Chair. So I actually am on Judiciary Committee, and I heard this bill in committee, and it makes sense. I mean, there was no opposition. There's no registered opposition that was taking a stance against this bill. I don't think there was any testimony against this bill, and it just makes sense. As the bill says, current law requires each county with a population of 2,000 or more to maintain a county jail. And what we heard, I remember specifically Lake County was very much in need of this, and it was going to save them significant amount of money in the future. So with that, I'm going to be an aye on this bill when it gets to thirds. Thank you.
Representative Garcia.
Thank you, Mr. Chair. And members of the committee, I just want to share that this is bipartisanship at its best. Thank you to my colleagues on the right for doing what you do best. Mr. Chair, I move L001 to House Bill 1050 and ask that it be displayed.
That is a proper motion. It is properly displayed. Is there to the amendment?
Thank you. So again, one of our great colleagues on the right side of the aisle informed me that within our ledge deck, we have a statement in our ledge deck that is referencing something that was originally in the bill but is no longer in the bill. So it doesn't make sense to keep in the ledge deck, so it's imperative for us to remove those 4 words so that it doesn't confuse things. And I ask for an aye vote.
Is there any further discussion on the amendment? Seeing none, the question before us is the passage of Amendment L001 to House Bill 1050. All those in favor say aye. Aye. All those opposed, no. The amendment passes. To the bill. Is there any further discussion on the bill? Seeing none, the question before us is the passage of House Bill 251050 as amended. All those in favor say aye. Aye. All those opposed, no. The bill passes. Mr. Schiebel, House Bill 20, please read the title of House Bill 251077.
House Bill 1077 by Representatives Leader and Ricks, also Senator Roberts, concerning requirements for individuals who work on backflow prevention devices and in connection therewith, removing the licensure requirements for individuals who inspect, test, or repair the devices.
Representative Leader.
Thank you, Mr. Chair. Good morning, colleagues. I move House Bill 251077 as amended. So we were
And the committee report.
and the committee report. Thank you.
To the committee report.
In committee, the bill passed 13-0. So we were the co-primes of the House Bill 241344, a bipartisan plumbing sunset bill. An amendment was added to the bill that we thought was clarifying the scope of licensed plumbing, but which inadvertently repealed the ability of national certified backflow technicians who are not licensed plumbers to inspect, test, and repair backflow devices. So before the passage of House Bill 241344, backflow devices inspections, testing, and repair could be performed by either a certified backflow control technician or a licensed plumber with a backflow control technician certification. So after the bill was amended, only licensed plumbers with such certifications were allowed to inspect, test, and perform repairs to these systems. So I will now pass it over to Representative Ricks to expand on the policy.
Representative Ricks.
Thank you, Mr. Chair. House Bill 251077 incorporates significant contributions from several parties, including the original House Bill 241344, the Water Interim Committee, water utilities, the plumbing industry, contractors, unions, backflow testing businesses, DORA, CDPHE, and others. House Bill 1077 will once again allow licensed plumbers and non-plumbers holding a current national certification to perform these services. We need this bill to ensure that Colorado has enough inspectors to protect the state's drinking water. We have added 2 amendments in committee, L004, which is an amendment that ensures that the existing regulatory framework for maintaining safe drinking water remains unchanged, that public drinking water systems will continue to receive reports on backflow assembly testing with oversight provided by the Colorado Department of Public Health and Environment through its regulators. L004 safeguards this process from disruption and eliminates the need for new regulatory rulemaking, making it cost-effective to implement additional amendments. It also guarantees availability of qualified professionals to test backflow devices, thereby preserving water quality and protecting our public health. And then L002 was also added, which clarifies the licensed sprinkler fitters are explicitly permitted to install or reinstall these devices on standalone fire suppression systems. The language in 1077 contained some ambiguity regarding this practice, and so this amendment aims to resolve that uncertainty. And with that, we ask for your yes vote.
Are there any further discussion on the committee report? Okay. Seeing none, the question before us is the passage of the Business Affairs and Committee report on House Bill 1077. All those in favor say aye.
Aye.
All those opposed, no. The committee report passes. To the bill. Representative Leader.
So after months and months of collaboration throughout the summer, everybody is in agreement with the bill, from industry, business, labor unions, all the departments, and we urge an aye vote to correct this problem as soon as possible. because the State Plumbing Board did an emergency stay until April of 2025. So this is why the expediency needs to be done ASAP, and I ask for an aye vote. Thank you.
Representative Sukla.
Thank you, Mr. Chair. This is a good bill. This saves the consumers money, and I encourage an aye vote.
Representative Richardson.
Thank you, Mr. Chair. I'm a member of the Business Affairs Committee. This bill did pass unanimously out of committee. Unfortunately, not because it represented a great new policy, but because, as you heard, it was necessary to save a legitimate business sector. This was a bill that was a sector that was accidentally placed on the chopping block by a bill passed last year without full consideration of the impacts. As a result, we threatened an entire industry. After nearly 150 years of statehood, do we really need 700 new bills a year? Well, unfortunately, the answer is obviously yes, because we want to do well, but we seem to measure what we do in terms of quantity of legislation versus quality of legislation. I ask that this body slow down a bit. We need to focus on the one line that we probably all know from the Hippocratic Oath, and that is, first of all, do no harm. Previous bill did harm. This bill corrects it. It's a good bill. It's got an unfortunate history, and it's one that should not be repeated. But I do urge a yes vote. Thank you.
Is there any further discussion? Representative Kelty.
Thank you very much for allowing me to speak. Actually, here's another one I'm excited about because it's another bill that fixes another bad bill that we've had before. So we're doing things together as legislators and fixing things from what we've done in the past. So I'm glad that we are actually looking at things and fixing them as we see them. It would be nice if we didn't put out bills that we had to fix. So I do agree with my colleagues that, we have to do quality over quantity. We need to slow down. The things that we do affect a lot of people, and I don't want to negatively impact them going forward. So let's just slow it down, let's take our time, and let's put good legislation out there, not bad. So that way we don't have to keep fixing things. But let's keep fixing the ones that we can. Thank you. I vote yes.
Seeing no further discussion, Representative Leader.
Thank you. I ask for an aye vote, and had these concerns, we stakeholdered this bill prior to the original bill. We stakeholdered it with everyone, industry in the departments. So had these concerns been raised earlier, alternative approaches would have been considered, but their late emergence necessitated months of collaboration efforts to resolve the unintended consequences, and the State Plumbing Board acted quickly, delaying the bill's implementation until April of 2025. So I ask for an aye vote. Thank you.
Seeing no further discussion, the question before us is the passage of House Bill 1077 on second reading. All those in favor say aye.
Aye.
All opposed? No? The bill passes. Mr. Schiebel, please read the title to House Bill 1035.
House Bill 1035 by Representative Paschal concerning changes to the Collaborative Management Program.
Representative Paschal.
I move House Bill House Bill 25, 1035, and the Health and Human Services Committee report.
To the committee report.
In committee, we added an amendment. This amendment clarifies about what can be shared with the courts. The court with jurisdiction to hear the case at issue may have access to the current service and support plan created by their individual service and support team. We also clarified that the family has the ability to give written consent by the child, youth, or family receiving the services to have their information shared. I ask for a yes vote on the committee report.
Representative Bradley.
Do I have to leave? You have to leave. Okay. I'm just kidding.
Thank you, Mr. Chair. I move HB 1035 L003 to the committee report and ask that it be displayed. Did I do that right? Yeah, do you have more of these? No, I had to give it out to all of them. Everybody's asking me. Oh, y'all got me in trouble, Vanessa.
That is properly displayed to the amendment.
So this amendment strikes the amendment that was brought into the committee that asked for the written consent of the child, youth, or family receiving services. This amends it to say the parent or legal guardian of the child or youth or family. I think this is a fair amendment, you guys. Listen, we heard from the Ute Mountain Tribe leaders, we heard from the governor. We are in educational deserts. We have 80% of kids who can't even read or write, and now we are going to ask our children to provide written consent to their records. They can't even read. What are we doing? Let's let the parents and the guardians consent to this and then talk the children through it. This is a fair amendment. We talk all the time. We have experts come testify that kids' brains don't develop to the age of 23, most say to the age of 25. Stop the hypocrisy. Please stop the hypocrisy in this building for our children. Parents and the guardians are in charge of the upbringing of their children. I love this bill. I testified in favor of this bill. I said yes in committee to this bill. So I'm asking, in the spirit of fairness, which we all talk about in this building, to accept this amendment. No 12-year-old can consent or understands the repercussions of letting anyone and everyone open to their medical records. I'm asking that the parent or legal guardian be the one consenting to it. It's a very minor change to protect children, which I think we're all on the same page of doing. Again, 80% of kids can't even read or write in our state. Maybe if we take that down a little bit, next year we can come back and allow 12-year-olds to consent to their medical records being given out. But until then, till their little brains develop a little bit better, let's make sure parents stay in charge of the upbringing of their children. I ask for an aye vote on this very fair amendment that I gave advance notice of. Thank you.
Representative Brooks.
Thank you, Mr. Chair. I would like to speak in favor of this amendment. I think it's very reasonable. I was in the committee actually just prior to one of my bills being presented, and so I had the opportunity to listen to the testimony that occurred there. Within the committee, it didn't seem like there was a whole lot of concern about any of the elements of this except for this particular clause about making sure the parents had the right to be notified. Personally, I mean, with 3 boys of my own, this is not something that I would want to have just pass underneath my radar, off of my radar, without being notified as a parent. I think that's a perfectly reasonable request. I think it is a good amendment. I would ask for an aye vote on the amendment, just simply so we can make sure that we're keeping parents in the loop and things are not happening with their children without their consent or knowledge. Thank you.
Is there further discussion on the amendment? Representative DeGraff.
Thank you, Mr. Chair. All right, so I'm pretty sure it's still the case that a 25-year-old can't rent a car. But at least that's the way when I graduated from college. It's part of the I guess the medulla oblongata thing, that the brain is not fully developed until a much later age than age 25. And we want to say that a 12-year-old can handle the implications of releasing their medical records. Once their medical records are released, there's a lot of information in those medical records, and I would imagine there's a lot of people that would really like to get their hands on those medical records. And we try to safeguard them, and then we create a bill where the kid can give his medical records away for a sucker or something. I don't know. That would be inducement, I think. So we have the issue with guns. You can't we say the kids can't handle a firearm below the age of 21, alcohol below the age of 21, cigarettes below the 20, and then we even have flavored vapes that we say that kids don't have the maturity to handle. But they have the maturity to handle their medical records which we have a whole body of governing regs around called HIPAA, and how they're handled, who can touch them, who can see them, who can modify them. Medical records are a very, very important thing to keep close hold. Not to turn loose to an elementary student for whatever reason. So this is a simple amendment. So, I don't know, maybe we could, instead of next year needing to come back to before the bill mill and do another bill to say, whoa, we probably shouldn't have released the kids' medical records or allowed 12-year-olds to play with their medical records. They probably don't even know they have medical records. They don't know the implications of releasing their medical records. So this should be an easy cleanup. Hopefully, over what would otherwise be an entire legal mess of releasing a 12-year-old's medical record. So it makes me wonder why this is in here at all. Who put this in there? Because it didn't go unintentionally. Why a minor being able to release their medical records was even a consideration in this is troubling. So this is a great time to slow the roll on the bill mill, look at the implications instead of the profit motives, strike this part out so we can protect the kids' medical records, which will have, releasing them will have lifelong implications. A 12-year-old releasing his medical records would have lifelong implications. So let's not do that to them.
Representative Kelty.
Just gotta put this down after. It's like putting the toilet seat down. Hello, and thank you for allowing me to speak. I appreciate that. So I'm in support of this amendment for I guess kind of the similar reasons. No one knows their child like a parent knows. They are our kids. We raise them. We see their first everything. From their first breath to their first step, for all that and everything that they do, including their medical information. Kids are too impressionable. They don't know even what a medical record is. I know I raised 2 boys, and the thought of them at 12 years old having their hands on just their passport or their social security card scared the crap out of me. Oh, sorry, I didn't mean scared the dickens out of me. And what could happen is if a child inadvertently, accidentally releases their medical records, it could end up in a very embarrassing or mentally distressing situation where they can't take it back. Once it's out there, it's out there. So legality start at 18. I really think that we need to keep things at 18 where they're more of an adult, even at 18. Whew, my teenagers. But a 12-year-old, a preteen is not someone that should be responsible for something as important as medical records. I mean, I safeguard mine very, very closely, and I think that's the parents' job is to protect their child, and that includes things like their medical records. So I want to put that back in the hands of the parents and let them do their job. They know their kid best. So, thank you.
Is there Representative Sander?
Thank you, Mr. Speaker. Mr. Chair.
Thank you
Mr.
very
Chair.
much. Maybe
Who's
someday.
standing next to Madam Speaker. Thank you. All right. I'll keep this short and sweet. There's buttons that move here. Okay, I've paid attention. I just didn't know where the buttons are. Thank you. I'll keep this short and sweet. Many of you are parents in here. Do you want your 12-year-old child making decisions on releasing medical records? So just think about the age of consent, the age of purchasing firearms, the age of purchasing cigarettes or alcohol. We give kids those milestones to have those privileges as they get older, but making medical decisions and releasing their medical records is a concern, and so I'd like to ask for an aye vote on this amendment. Thank you.
AML winner.
Thank you, Mr. Chair. I urge an aye vote on this amendment, and all I ask you, colleagues, as we debate language of bills throughout the rest of the year, I ask for consistency. I know that this year, I'm sure there will be legislation that will be in here regulating certain things based upon age, and I just hope that as we move down the line, for those of you that aren't willing to vote for this amendment, that we have consistent conversations as we talk about regulating what kids can and can't do. I urge an aye vote on this. Thank you.
Representative Bradley.
Thank you, Mr. Chair. I missed you so much, I thought I'd come back. I agree. I just listened to testimony for 2 hours yesterday about consistency of verbiage, medical necessity, things like that. It's important to have consistency in language, not when it's just about your bill. It should pertain to children too. Cigarettes, alcohol, vaping, we don't allow children to do any of those. We certainly shouldn't let them consent to written consent of their medical records, something very, very important that lasts throughout your lifetime if they can't even read and write. So at least add stipulation that they have been tested, that they can actually read and understand what they're signing. Protect the kids. Don't just be here to pass bills. I urge an aye vote. Thank you.
Representative Pascal.
To answer a couple of the questions on here, first, for those who read the bill, you realize there is a very clear list of organizations and people, entities, types of providers that the records can be shared with. This is not a child, somebody sharing their records on the street for a sucker. Also, child means the age of 12 and above is what their criteria is, and I would be more than happy to put that amendment in there. But I am not interested in taking away the rights of teenagers to be able to direct their care so for instance, say, I need to see a therapist about something. So I urge either a no vote on this amendment, or if you want to bring another amendment forth, somebody wants to bring a change to the amendment forth, that would be something I might consider.
Representative Lott.
Thank you, Mr. Chair. If the definition of child is 12 and above, can you provide us with a definition of youth?
Seeing no further discussion on the amendment, the question before us is the passage of Amendment L003 to the committee report. All those in favor say aye. All those opposed say no. The amendment fails. To the committee report. Is there further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye. Aye. All those opposed, no. The committee report passes. To the bill. Is there any further discussion? Representative Pascal.
I just want to give a quick overview of what this bill is about. The Collaborative Management Program is a program with a multidisciplinary team that will intervene if a child is considered to be an at-risk youth. This is a program that is run by the Colorado Department of Human Services, but it is an opt-in program for the counties. No one is forced to be involved in it. And what the bill does is it just expands the entities with which a memorandum of understanding can be entered into with the care team. The entities are the court that is at jurisdiction if there is a case involved, and changing it from calling out a specific care provider within the bill to referencing a different area and statute that lists a standardized list of care providers. I urge a yes vote on this bill. It is, this is a vulnerable community that we are attempting to help. So I urge a yes vote to correct this oversight in the original bill.
Representative DeGraff.
This could be a very necessary bill. I don't care. Noted. Thank you. This does not have the provisions, without that amendment, this does not have the provisions for the safety of our kids. So for whatever you're going to solve, are we just going to like be running another cleanup bill next year to protect the kids that were not harmed by this in this last year? Oops. We forgot a couple words, and now we've got this whole thing with water, and we're not going to be able to have our backflow inspections because we didn't understand what was going on. We didn't slow down. Oh, we're just going to let the kids release their medical records without having any clue what they're doing. The rest of this bill might be okay. Reminds me of a little bit of civil engineering when you study city planning. 99% of sewage is pure water. 99% of this bill might be good, but when you don't protect the kids of this state by intentionally including wording in a bill because you had the opportunity to remove the wording, so by intentionally making sure that you keep the wording in that bill that victimizes the children of our state, this is a victimizing bill. The intent of this bill now becomes the victimization of our children and the release of their medical records with a bunch of other garbage to gussy it up. It's predatory. That happens a lot in this room. It's a very small thing. We could have removed it, and it should have had nothing to do with it. But this body, the majority, decided that the most important part of this bill was victimizing children.
Representative DeGraff, careful.
I'm sorry that it was the most important part of the bill. This bill victimizes children. This bill will create victims. It could have been fixed, easily fixed, given the opportunity to fix it. Those words in the bill now become the intent of the bill. If they were inadvertently added, they were intentionally kept. A bill intended to victimize is a bill that's presented by predators. Protect the children.
Committee will stand in a brief recess. The committee will come back to order. Is there further discussion on the bill? Representative Johnson. You are recognized.
Thank you, Mr. Chair. It's an honor to serve with you. I move L002 to House Bill 1035
And
ask that it be displayed.
Thank you. This is properly displayed to the amendment.
Thank you, Mr. Chair. So this amendment is striking the safety clause and moving to put it as a petition clause. We have overused safety clauses way too much in this state, and we need to allow for the people of Colorado, per the state constitution, to have the ability to petition and have say on this as well. We have heard many times at the well that we have been speeding up the process, and this is a time to slow it down to catch anything that might be missed. So I encourage a yes vote on this amendment.
Representative Paschal.
Well, this amendment, unlike the previous one, was actually brought up in committee. So I do appreciate that. But I believe that this is the type of item that really is appropriate for the safety clause. There are people out there that are in need of services who are our most vulnerable folks that we would be denying service from. And I think this is an appropriate application of the safety clause.
Representative DeGraff.
The most vulnerable here are the 12-year-olds. And their parents, when they see the wording of this bill, that intentionally allows the child, the minor child, who's not allowed to enter into any sort of contract. I did look it up, 21 years old for most car rentals, if you have meet some certain stipulations. 21 for a car, 12 years old to handle your medical records. HIPAA is a lot of training for adults, a lot of training to protect
Representative,
that.
to the amendment?
Yes, sir. This is to the amendment.
To the amendment
We are-
about the safety clause petition?
The safety clause, the safety clause is now to bypass the opportunity that parents have to potentially gather a petition together to reject the idea that maybe their 12-year-old should be able to release their medical records. That's what the safety clause is now doing. Yeah, the safety clause would have been a good idea to make sure that people got their services that needed, but now this safety clause is a bypass to make sure that parents do not have the opportunity to petition the government, as is their First Amendment right, to not allow their 12-year-old to release their medical records with lifelong implications. Thank you, sorry. The safety clause here is now in an intentional end run around parents who might want to petition the government. And the reason for end run around parents being able to petition the government is to ensure that 12-year-olds can release their medical records having absolutely no clue what they're doing. This bill is going to create victims, and we're putting a safety clause on it to make sure it happens as quickly as possible. And the only concern is that previously I said predator. Vote no. Vote yes.
Seeing no further discussion on the, oh, sorry, Representative Bradley.
Thank you, Mr. Chair. This program has been in place since 2004, for 20 years. There's no reason to have a safety clause in this. We're inevitably usurping parental rights, and now we're usurping the rights of the people to petition the safety clause. And the people are begging us to stop doing this. The people are begging to have their rights back. And in a bill where a program has been going for 20 years, we're now saying, by God, we have to have a safety clause. It's of the utmost importance. We're saying that we need safety for these children, but in the same sentence, we're saying that 12-year-olds can consent to have their medical records released. So my head's spinning, because in one sentence we're saying one thing, and the next sentence we're saying another thing. So safety of the children to have the programs, but we don't care if they can understand the legitimacy of having their medical records released, because we don't even know if they can read or write about letting their medical records be released. This is ridiculous. There's no reason for a safety clause to be on this bill. It's been 20 years. Time is not of the essence right now. It can wait 90 more days after the governor signs the little bill into play, like the 700 bills he signed last year, and we can put a petition clause. It's a fair ask for my caucus, and I ask for an aye vote. Thank you.
Representative Soper.
Thank you, Mr. Chair, and it's an honor to serve with you.
It is an honor to serve with you, Representative.
Thank you, Mr. Chair. And it's a beautiful morning, members. I come up here because often we have debated the difference between a safety clause and a petition clause, and it really was only in the very modern era of the legislature that the safety clause began becoming the norm. Before that, the standard was the petition clause, and it's important to go back and to look at what the difference is between the safety clause and the petition clause. So for example, we have to go back to our Constitution here in Colorado. Article 5 Section 1.3 of the Colorado Constitution reserves to the people the powers to refer all or a portion of an act to the ballot for voter approval. There are two exceptions to this power. One, laws that are necessary for the immediate preservation of public peace, health, or safety. And two, appropriations for the support and maintenance of the state departments and state institutions. To invoke the first exception, the General Assembly includes language in a bill referred to as a safety clause, which is derived from the language in this first exception. Case law concerning the safety clause in legislation clearly states that the General Assembly may prevent the people from referring an act to the ballot by declaring that the act is necessary for the immediate preservation of the health, safety, and welfare of the state. Furthermore, the General Assembly is vested with the exclusive power to determine whether that declaration is appropriate. The question before us right now is whether it's appropriate to have a safety clause or a petition clause on this particular bill. That would be for this body to determine. And that's what we're here debating with this particular amendment. While the language is here as a safety clause, we're arguing that it should be a petition clause. What happens, what's the effect of a petition clause? It means the public has 90 days to get the requisite number of signatures to challenge this particular act of the General Assembly. If you're curious, that's only been done twice in the last 100 years, so the odds of that happening are very, very low. So if there's a fear that somehow by having a petition clause that's going to cause the entire bill to be undone, looking at the hundreds of bills and the fact that only twice in over 100 years that that's happened is very rare. The other thing that's important about the petition clause is that it honors the first clause in the Constitution, that it's the power reserved to the people of referendum, and it shouldn't be swallowed up by an exception that was only meant for a very narrow use. I do want to dive into a little bit on sort of how the courts have seen this. Specifically in 1913, when the Colorado Senate asked the Colorado Supreme Court whether the General Assembly could lawfully prevent a proposed act concerning an 8-hour workday and persons employed in mines from being referred to votes of the people by the use of the safety clause, saying it concerned health and safety, the Supreme Court held that the General Assembly had the authority under the constitutional language to determine, and they passed the question as such. A few years later, in Van Kleck against Ramir, the Colorado Supreme Court affirmed its 1913 ruling. I will go on to say that this stands a little bit on shaky grounds, certainly in current case law, that when it has been challenged, it can go to the state Supreme Court, and we can look at whether or not it truly was appropriate or not. I would argue in this case, a petition clause is clearly appropriate. Give the 90 days. That's not a lot of time. That's less than a legislative session. It's a bit of a cooling off period if you think of it that way. But most laws don't even take effect before 90 days after the General Assembly adjourns anyways. So it's really a win-win on both sides. Thank you.
Seeing no further discussion on the amendment, the question before us is the passage of Amendment L002 to House Bill 1035. All those in favor say aye. Aye. All those opposed, no. No. The amendment fails. To the bill. Seeing no further discussion, the passage before us is the question before us is the passage of House Bill 1035. All those in favor say aye. Aye. All those opposed, no. The bill passes. Mr. Shebel, please read the title to House Bill 1081.
House Bill 1081 by Representative Martinez, also Senator Weissman, concerning reporting statistics on restitution payments.
Carry the bill with you.
Representative Martinez.
Thank you, Mr. Chair. I move House Bill 1081 in the Judiciary Committee report.
To the committee report.
In committee, we we had to make some adjustments into the bill to reduce our fiscal note, making good governance, and being able to improve our reporting data. So we asked for an aye vote.
Is there any further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye.
Aye.
All those opposed, no. The committee report passes. To the bill, Representative Martinez.
Thank you, Mr. Chair. So today we are bringing up a bill that takes a look at restitution. For those that don't know, in case you don't know, I'm from the San Luis Valley. Which is one of the poorest districts in this state. And what did I get told when I was on the campaign trail is that there was questions on where restitution money was going and who was paying that money. And so we were looking at this bill and seeing what we could do to being able to get that data, to being able to really determine what was going on. That's what this bill does, is it measures who's paying that restitution and where it's going. And that way we have a more accurate list of what's going on. Also with this, the district attorneys are supportive of this. The victims' rights advocates are also supportive of this. Colorado Criminal Justice Reform Coalition and Stand for Children are also supportive of this because they want to see where that data is and they want to be able to get more accurate reporting and being able to determine what's going on. So we requested an aye vote.
Representative Soper.
Thank you, Mr. Chair. And while I missed hearing most of the bill in committee and was a little confused, I will say this is a very good bill. And anytime we can get more data, particularly in terms of restitution, that's definitely a good thing. Given the debate I just had on the previous bill, though, I won't reiterate what I just said, but this is appropriate here to have a petition clause, and I move Amendment L004 and ask that it be properly displayed.
Amendment L004 is properly displayed to the amendment.
Thank you, Mr. Chair. So this amendment adds a petition clause to the bill. After all, asking for more data at the 2026 SMART Act hearing is not part of health, safety, or general welfare of the state to immediately enact, and it's certainly not for the preservation of a State Department's budget. And because it doesn't fall within those two exceptions within our Constitution, a petition clause is appropriate here. And quite frankly, if judiciary can't get this done from like midsummer to the end of December, there's other problems that we have in our state government. And I'd ask for a yes vote.
Is there further discussion on the amendment? Representative Caldwell.
Thank you, Mr. Chair. I just want to speak in favor of this amendment here. Again, the safety clause and my colleague from Delta really explained it on the last bill, but I just feel like it's an abuse of the safety clause, which can be common, it seems like, more and more these days. This has to do with SMART Act hearing reporting. We just had our SMART Act hearings. We have an entire year to collect this data. Why does it need a safety clause to go into effect right away? Let's do the petition clause. Let's not abuse the safety clause and save that for when we actually need to use it for crime or something like that. So I want to speak in favor of this amendment.
Representative DeGraff, welcome back.
Thank you, Mr. Chair. I just wanted to drag out the discussion on the safety clause just enough to make it a little bit on the punitive side so that at some point people will say, hey, maybe we don't put up a safety clause on everything because I can, and we reserve the safety clause for things like, I don't know, safety and emergencies. If everything's an emergency, nothing's an emergency. So I am in favor of this. I'm in favor of this because this is not an emergency. I think this data is probably already being collected. We'll talk about that again. And this is an area that we can focus on good governance instead of trying to do an end run around the people of Colorado at every single turn of the bill mill. So this is a good amendment to make sure that our processes are done correctly and we're not abusing the citizens of Colorado.
Seeing no further discussion on the amendment, the question before us is the passage of the amendment L004 to House Bill 1081. All those in favor say aye. Aye. All those opposed, no. The amendment fails. To the bill. Seeing no further, oh, sorry, are we still on the committee report? I thought we were past that. What are we doing? We're on the bill. To the bill. Representative Martinez. The House will stand in a brief recess. The committee will come back to order. To the bill. Representative Martinez.
Thank you, Mr. Chair. We request an aye vote.
Seeing no further discussion on House Bill 1081, the question before us is the passage of House Bill 1081. All those in favor say aye. All those opposed, no. The bill passes. Mr. Shebel, please read the title to House Bill 1034.
House Bill 1034 by Representatives Garcia Sander and McCormick, also Senator Doherty, concerning amendments to the dangerous dog statute.
Yes, I can do that.
Representative McCormick. Representative Garcia Sander.
Thank you, Mr. Chair. I move House Bill 1034.
To the bill.
To the bill.
Representative McCormick.
Thank you, Mr. Chair. This bill makes a change to the dangerous dog statute. Currently, the statute says that dogs and owners that have caused bodily injury or serious bodily injury, and there's an important distinction between those two, or the death of a person or domestic animal, will be placed on the dangerous dog list under our law, and they may have to go through some certain things according to what the judge, once they go through that adjudication process. So currently in law, the folks that are exempted from owner liability for certain professionals that frequently work with animals, it includes veterinary staff, dog groomers, animal welfare professionals, animal control agents, dog handlers, and trainers. And the problem with this exemption is not that the folks that are in these professions take on a certain degree of risk. That risk will continue. They accept that risk for serious bodily injury or bodily injury. The problem occurs when that animal is not placed on the dangerous dog list. Then that animal is a further risk to kids, other animals, and people in society, and that's where the problem lies. And so removing that exemption, that those dogs will not be able to slip through this loophole, we can further protect our communities and know where these dogs are and make sure that they're kept under safe and secure conditions. So, and it's just removing the exemption for serious bodily injury, which is defined as serious risk of death, substantial risk of serious permanent disfigurement, substantial risk of protracted loss or impairment of a function of an organ or body. These are not just bites. These are not just bite wounds that might be bleeding and you have to go to urgent care and get on antibiotics. This is to the nth degree level higher. This is really a problem where this animal has gotten through all the defenses of the experts that are handling animals and still caused serious bodily injury. So I do urge a strong aye vote on this. This is a public safety measure, and hope you all can support it. You go.
Is there any further discussion on the bill? Representative Garcia Sander.
Thank you, Mr. Chair. We heard some very compelling victim testimony of a man who had been injured by a dog. And we talked to law enforcement officers. I spoke with our county sheriffs up in northern Colorado, and they are very supportive of this bill. Just because they've accepted the risk of working in the fields that they do doesn't mean that if they have a serious bodily injury, meaning a broken leg, broken arm, serious disfigurement, that dog shouldn't be listed on a dangerous dog list, so that people aren't aware of that in the future. So I ask for an aye vote on this. Is that it?
Seeing no further discussion on the bill, the question before us is the passage of House Bill 1034. All those in favor say aye. Aye. All those opposed, no. The bill passes. Mr. Sheba, please read the title to House Bill 1003.
House Bill 1003 by Representative Stewart Arden Brooks, also Senator Cutter, concerning a Medicaid waiver program for children with complex health needs.
Representative Brooks.
Mr. Chair, I move House Bill 25-1003 and the Health and Human Services Committee report.
To the committee report. One second. Representative Stewart, my apologies.
Thank you, Mr. Chair. The amendments on the committee report are quite simple. It was a request from our stakeholders to ensure that the language in the bill reflected the name of the new consolidated waiver, as well as clarifying a section of applicability to ensure that there is a full year for families on the CHCBS waiver to transition onto the new children with complex needs waiver. And I ask for an aye vote.
Any further discussion on the committee report? Seeing none, the question before us is the passage of the committee report. All those in favor say aye.
Aye.
All those opposed, no. The committee report passes. To the bill. Representative Stewart.
Thank you, Mr. Chair. My co-prime Representative Brooks and I are bringing House Bill 25-1003, which is a bill to merge the Children's Home and Community-Based Services waiver with the Children with Life-Limiting Illnesses waiver and create a new waiver called the Children with Complex Health Needs waiver. This legislation will streamline home and community-based services for children's waiver programs, expand access to critical services, and will ensure that current CHCBS members have continued access to waiver services, and I urge an aye vote.
Representative Brooks.
Thank you, Mr. Chair. This is something that I believe is truly just non-partisan, not even bipartisan. This is just simply ensuring that families with complex health needs children are not frozen out of Medicare coverage. And I will speak to the safety clause nature of this bill. I understand that there is some consternation, and understandably so, with safety clauses occasionally, but in this particular case, it speaks to the very nature of the bill. Without the safety clause and something that can go into effect immediately, it almost renders the bill useless, because what we're trying to do is ensure that there is no gap in coverage. If a safety clause was not used in this particular case, then that means there'd be probably at least 30 days or so where families would not have coverage. We're trying to specifically avoid that, and so I believe that in this case is judicious and just use of the safety clause, and I would ask for an aye vote.
Seeing no further discussion on House Bill 25-1003, the question before us is the passage of the bill. All those in favor say aye. Aye. All those opposed, no. The bill passes. Madam Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
You have heard the motion. The committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bills 1003 as amended, 1034, 1035 as amended, 1050 as amended, 1077 as amended, and 1081 as amended, passed on second reading, ordered, engrossed, and placed on the calendar for third reading and final passage.
Representative Clifford. Members, you have heard the motion. There are amendments at the desk. Mr. Shebel, please read the Bradley amendment to House Bill 1035 of the report of the Committee of the Whole.
Representative Bradley moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Bradley Amendment L3 to House Bill 1035 to show that said amendment passed, that House Bill 1035 is amended passed.
Representative Bradley.
Thank you, Madam Speaker. I move House Bill 1035 H001 amendment to the report of the Committee of the Whole and ask for an aye vote.
And we will make sure it is properly displayed.
Thank you.
And just a note, Rep. Bradley, you can just move the Bradley amendment. Not a big
I like
deal.
to talk, I'm Southern, so.
Okay. Please proceed. Please proceed.
Thank you, Madam Speaker. The good representative from El Paso says that I'm yelling. I'm Southern, you guys. I'm not yelling. I mean, we just speak one vocal notch. So I'm going to try to talk a little quieter. Is that better? Okay, there we go. I can't talk like that. The CMP is a collaborative management program. And what this does, and I want you guys to hear me and understand me. I am not against this bill. I voted yes on this bill. The problem I have is with the amendment, okay? So this is partnering with children that are very underserved and youth, sometimes in crisis. So this is working with local judicial districts, health departments, school districts, community mental health centers, and behavioral health organizations or regional accountable entities, parent or family advocacy groups, and community agencies. That's great. This helps with cost sharing. It's a great program. 51 counties participate in it. The problem I have is that we then brought an amendment that says written consent of the child, youth, or family. And by the own admission of the bill sponsor, we are saying a child is 12 and younger. I want you to tell me how a 4-year-old provides written consent to their records. I brought an amendment that said, let's not do that. Let's not open the door for mass confusion for this wonderful program that 51 counties are in business with. We're going to have to come back next year because parents are going to sue. Parents are suing all over the state, in your districts, in my districts. There's a great amendment that would help provide clarity and stop the confusion. A 4-year-old, you guys, cannot provide written consent for their records by definition. And honestly, in the CMP program, they don't even define what a child, a youth, or even a family member is. This is not me trying to be argumentative. This is me trying to protect children. CMP broadly uses the term child, youth, and family without a specific definition. There's no definition of family. Is that an uncle, a second cousin, someone who pretends to be a best friend of the family? Some of these kids are the most vulnerable and underserved, and I know you can say a lot of things about me, but you know I fight for children in this space. We have a great amendment that will provide clarity and instruction, and it was just voted down, so I'm asking you to take that back. I'm asking you to make sure that children aren't providing written consent. Let's go back to the table, and maybe we provide a better definition for youth, but we can all agree that no one under the age of 12 can provide written consent and understand what that means. When you stakehold, you bring everyone to the table, including mama bears who fight for children. A 4-year-old cannot provide written consent. They don't even understand what that means. I would say that 12 and 13-year-olds don't even understand what that means. We have to protect these kids and what they're signing up for. And that's why we have great parents and guardian ad litems and people that we have to protect children in this space. This is a great program. This is a great bill. There was no reason to bring an amendment that says written consent of the child, and by the bill sponsor's own admission said that that's anyone under the age of 12. Youth or family. This has got to be cleared up because we are going to come back next year to lawsuits filed by parents who find out that their 4-year-old was coerced into a signature. We don't want that. We don't need that. This is a good program. Let's clean up the language. Please vote yes on this amendment. Thank you.
Representative Pascal.
The age is 12 and above, not 12 and below. 4-year-olds do not write consent on medical records. If this issue was truly this important, it might have been brought up in committee or spoken to me before, 1 minute before I came up here. This is pure hijacking for political rhetoric.
Representative,
Oh.
one moment, please. Representative Bradley, 1 moment, please.
The rules apply to everyone.
Pascal,
I urge an aye vote, a
Representative
no vote.
Pascal. We will stand in a brief recess. The House will come back to order. Representative Pascal.
I apologize to the Committee of the Whole for violating the rules. I'm sorry I did that. I urge a no vote.
Thank you. Representative DeGraff.
Thank you, Madam Speaker. I urge a yes vote. For the reasons I stated before, this is not political grandstanding. This is trying to fix what would otherwise be a very good bill, at least according to my colleague who has told me over and over that this is a very good bill and would like to vote for it. So we're trying to fix it. And something that my colleague brought up is the word family. And if you remember from our housing regulations last year, we pretty much obliterated the word family. So I don't know if the word family that in terms of housing means anybody that means anything to you, or whatever the definition of family became, anybody to whom you feel a kinship or something like that. I don't know if that applies here, but I don't know how we would use the word family different here than we would use family in terms of making medical decisions. And is that somebody's brother, sister? This is a very loose set of words. It sounds very legalese, but it has a lot of implications. And the purpose for my colleague trying to strike that out is so that we can support the bill. Now, my colleague, who is adept in the medical field, actually licensed and practicing in the medical field, I'm a little bit more inclined towards her definition. And if the definition of child can include all the way down to 4, I don't know what the definition is, but anchoring it in saying that a child has to be over 12 to release their medical records? 12. That's hardly a point of comfort. Lots of good stuff in this bill. Now, the allegations that just coming here and doing this at the very last minute, well, that's just a matter of this being a bill mill. We used to have people up in the gallery. The purpose of the gallery is oversight. The purpose of the gallery is that so the citizens of Colorado could come in and watch how the bills are actually produced, the laws. Now most of the bills are produced in back rooms with an initial hearing in committee, and then rubber stamped on the floor, churning through 700 bills a year. Less than 2 hours per bill if we did 12-hour days. And so it is very conceivable that you're going to miss some details like this. It doesn't make them unimportant. It doesn't mean calling them out as political grandstanding. I think I won't even say. But we offered an amendment to remove the problematic language. It's nothing personal. Remove the problematic language so we can vote on the bill, so we don't have children, for whatever reason. I don't know why they would release their medical records. I don't know what member of their family would release their medical records. I don't know what sibling might release their medical records, but I know from looking at this, it sure makes it look possible. And that is not safeguarding the rights of citizens. It is not safeguarding the rights of the vulnerable kids that we have in this state. That to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. That to secure these rights, among which life, liberty, and the pursuit of happiness. You could say those medical records are their property. We need to maintain those as their property. We cannot just allow something like this to actually go and create an avenue for the exploitation of the kids' medical records. Medical records are very, very, very valuable, monetarily valuable. This is not some benign language. This is very dangerous for the kids in this state. So I recommend an aye vote. Protect the kids. This is not grandstanding. We just ask that the problematic language be removed. That's all. Remove the problematic language so we can support the bill, or so I can support the bill. I can't speak for my colleagues. I won't speak for my colleagues. But you're taking what seems like a very good bill and you're turning it into something that unfortunately I can't support. I recommend an aye vote on this. Get rid of the problematic language. Make it something we can support.
Representative Barone.
Thank you, Madam Speaker. I also am in agreement with this amendment. As a parent that's going to have a 12-year-old this August, I do want to know who is asking for my kids' medical records. knowing what my kid, he still loves Pokemon cards. Like, he doesn't know who's going to get his medical records or how valuable those medical records are. I do not want him to be able to have written permission to give his medical records to anybody without me knowing. I don't think he's going to know the importance of it until he's probably in high school. So I also agree with this amendment, and I urge an aye vote, please, as a parent that's going to have a 12-year-old this year. So I appreciate it very much.
Representative Kelty.
As mentioned earlier, oh, thank you for letting me speak. As I mentioned earlier, when it comes to medical records, there's a lot of things in there that could get a kid in a lot of trouble, that could really ruin their life. We see kids right now, they go online, they put that picture, the picture they shouldn't put, out online, and it stays there forever. This is the same type of thing. Once that data is out there, that information is out there, they can't take it back. There could be some extremely harmful things in their medical records that they either forgot about, don't realize. And I would hate to see that information. Like, for example, I mean, kids at that age can do different things. Maybe there's something disease-wise, sexual disease, something like that that's in there that could actually ruin them. Once it's out there, you can't take it back. So I really would like to pass this amendment just so we can identify that little ones, 12-year-olds, little ones, they don't have the capability to make that kind of decision. They just don't. Anyone who's had a 12-year-old can tell you, they just don't, unless you had that exceptional kid, but that's not the majority. And those are the ones that we have to protect all of them, right? Even the silly ones, and like I had. So please consider the fact that 12-year-olds, the majority of them are not capable, right? You don't want that information out there. That gets out there. We already have kids committing suicide over things they put online, and it comes back to bite them. Can you imagine what this would do to them? So please really think. Thank you.
Representative Bradley, this is your second time to speak to the amendment.
Thank you, Madam Speaker. I'm going to take the high road. Again, CMP does not define child. So if you don't define child, it opens up a lot of loopholes. That was my only point. I did not say 4-year-olds are going to provide written consent. Hear me. I'm just saying that it just says child, and then it says youth. Most statutes and other areas of law make a definition at 12. So children are defined as under 12, and youth are defined as above 12. That is the clarification. If the amendment had just said maybe written consent of youth and family, I could understand. But the child in there brings up a point for me that 4-year-olds could have this access, and that scares me as a parent. And I want to always safeguard children. Political grandstanding, come on. I got an amendment, this amendment, from the bill sponsor last minute in committee. I didn't get it the night before her bill was heard. I got it the very last minute, passing it out after the bill was heard. I didn't go to her and say, that's disrespectful, you're passing this out the same time the bill's being heard. That's what we do. I came to her and asked her about this amendment before floor work, because I didn't want to come to the well and land blast. I had questions about it, and I wanted some clarification. So don't come up here.
Representative Bradley, I'll just pause you there. Appreciate your statements on the process. Please return to the amendment.
Okay. Thank you, Madam Speaker. I will always advocate for children, the safety of children. I will always advocate for parental rights, and none of that has to do with grandstanding. Thank you.
Thank you. The House will stand in a brief recess. The House will come back to order. The question before us is the adoption of the Bradley Amendment to House Bill 10, to the report of the Committee of the Whole. Mr. Schiebel, please open the machine and members proceed to vote. Representative Bottoms, how do you vote?
Yes.
Representative Bottoms votes yes. Representative Garcia. That will be a $4 fine. Please close the machine. With 27 aye, 38 no, and 0 excused, the amendment is lost. Mr. Schiebel, please read the Martinez-Soper amendment to the report of the Committee of the Whole for House Bill 1081.
Representatives Martinez and Soper move to amend the report of the Committee of the Whole to reverse section taken by the committee not adopting the following Soper Amendment L4 to House Bill 1081 to show that said amendment passed and that House Bill 1081 is amended passed.
Representative Martinez.
Thank you, Madam Speaker. I move the Martinez and Soper Amendment to the Committee of the Whole report and ask that it be properly displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. So we actually do want to enact the petition clause on our restitution bill, and we request an aye vote. Thank you.
Seeing no further discussion, the motion before us is the adoption of the Martinez and Soper Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine, and members proceed to vote. Representative Bottoms, how do you vote?
Yes.
Representative Bottoms votes yes. Please close the machine. Wow. With 65 aye, 0 no, the amendment is adopted. The motion before us is the adoption of the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Bottoms, how do you vote?
No.
Representative Bottoms votes no. Representative Carter. Please close the machine. With 44 aye, 21 no, the report of the Committee of the Whole is adopted. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar till January 31st, 2025.
Seeing no objection, the balance of the calendar will be laid over until tomorrow. Members, announcements and introductions. Representative Titone.
Thank you, Madam Speaker. Members, this is a really important one you got to pay attention to. If you have not seen what's in the Treasury with the respect to unclaimed property, today is the day, because today we're here to celebrate the Great Colorado Payback in honor of National Unclaimed Property Day this Saturday. And did you know that 1 in 10 Coloradans have unclaimed property? That could be anything from unpaid wages to lost gift cards, mutual funds, or precious family heirlooms. In fact, the Great Colorado Payback holds $2 billion in unclaimed property owed to more than 7.5 million rightful owners, including 27 of you in here. Listen to that. 27 of you have unclaimed property. So you should check to see if you or anyone watching or listening have unclaimed property, go to greatcopayback.com, search for your name and zip code, and today might be your lucky day. And if you want to go downstairs to the treasurer's office, the Great Colorado Payback is hosting an open house from 11 to 1. There's really cool things like gold bars and expensive diamond-crusted watches and all sorts of neat stuff you can see. It's a really, really unique chance to get close up to things normally you would see in a museum. So go down there to the treasurer's office and go check to see if you have unclaimed property and claim what's yours.
Representative Lindstedt.
Thank you, Madam Speaker. Joint Finance Committee members, we will be meeting with the JBC members on adjournment here in the Old State Library. See you there.
Thank you. Representative Lukens.
Thank you, Madam Speaker. The Education Committee will be meeting at 1:30 in room 107 to hear House Bill 1006.
Thank you. Representative Wilford.
Thank you very much, Madam Speaker. The House State Civic, Military, and Veterans Affairs Committee will meet promptly at 11:10 across the street in LSBA. We'll hear House Bill 1065 and House Bill 1025. Thanks.
Representative Barone.
Thank you, Madam Speaker. A quick reminder, members, today is the API luncheon for the oil and gas industry. Please come down. It's going to be in Guitarra, 1778 Grant Street here in Denver, from 12 to 1:30 p.m. Come over here and talk to the great people of the oil and gas industry and how they help this state with the funding and the great things that they're doing. Thank you.
Thank you. Representative Byrd.
Thank you, Madam Speaker. So, members, I am coming to let you know where the JBC will be because I know you were wondering. So today, as soon as we adjourn, we will be joining the Joint Finance Committee to give our Rule 25 mandated SMART Act hearing. So come if you'd like to learn about that. And then I have yet even another JBC announcement. So if you care about the budget and want to understand state finances, you'll want to listen and mark this down. So JBC staff will be offering a training session on the state's budget and the supplemental process tomorrow, Friday, January the 31st, from 8 a.m. to 9 a.m. in House Committee Room 112. So that's down in the basement. If you can't be there in person, a virtual option is available. And just so you know, the training is open to all legislators, staff, aides, interns, and all others in the legislative community. So if you can and you have interest, please plan to join JBC staff tomorrow morning. I think it will be very helpful because in 2 weeks, this body will be working on supplementals, so you'll be ready.
Thank you. Representative Taggart and then Representative Ricks.
Thank you, Madam Chair. I would just like to invite you tonight. There is a reception at the Art Hotel starting at 5 o'clock for our largest university in the Western Slope, Colorado Mesa University, which happens to be one of the most innovative universities in the state, and I'd love to see you there. Thank you.
Thank you. Representative Ricks.
Thank you, Madam Chair. House Business Affairs and Labor Committee will be meeting at 1:30 this afternoon in House Room 112. We're going to hear 3 bills: House Bill 1020, House Bill 10001, and House Bill 1075. See you there.
Thank you. Representative Marshall.
Thank you, Madam Speaker. So tomorrow, colleagues, we are having the Professional Land Surveyors Legislative Breakfast outside the old Supreme Court Library from 7:30 to 9. Show up and talk to the people. Don't just grab the burrito and run, because land surveying is actually a very important subject. You make one screw up, it could follow and become a problem 100 years later. And the technology they're using now is extraordinary. So do show up and talk to the people. Thanks.
Thank you. Representative Woodrow.
Thank you, Madam Speaker. Colleagues, I have received permission from the Majority Leader to be absent tomorrow, January 31st, and Monday, February 3rd. I will miss you all dearly. Thank you.
So approved. Members, I have an announcement. I will be absent tomorrow, January 31st. And I guess Majority Leader approved that for me.
Yes.
Thank you.
Yes, I did.
Seeing no more announcements, Madam Majority Leader.
Thank you, Madam Speaker. I move the House stand in recess until later today.
The House will stand in recess until later today.